Okay, my name is Jim Bowen. I'm an enrolled member of the Jamestown. You don't have to write any of this stuff down, especially this part, which is really hard to remember. But I will give $100 to anybody. Oh, just in time to introduce me.
I brought some extra water for you. You're welcome. We brought Uncle Jimmy up here, I think, for the first time in 1981. I was the administrator for the Sitka Tribe at the time, and we were working on developing codes, child welfare codes and other codes. And at that time, we were trying to assert as much authority as possible, and there was a Indian housing project that had begun in the late 60s, and it still had not come to fruition in 1980. So we were, bugging the Department of Housing and Urban Development to, give us the authority, turn the project over to us, and people were saying, well, you just can't do that. You can't organize your own housing authority. It's not possible. Alaska's a 280 state. Tribes don't have any authority. So there's a couple of attorneys that came up from, I forgot the Indian law program in Washington, D.C., and they said, who says you can't do it? Just do it. So anyway, we did it. And then that started us a chain reaction process on doing a lot of other stuff that Alaska tribes had never thought they could do. And so the next step was to begin the development of laying the foundation for developing a tribal court. And so Jimmy came up for a series of conferences, and he did consulting with us on developing the basis for a tribal court. And at the time, he was the chief judge for the Puyallup Tribal Court. And we went on a lobbying trip together with the Central Council. Jimmy, he was working on his tribe's constitution, the Jamestown S'Kallam Tribe constitution. I think that trip was in what, 1983? So I had known him over a period of years, and I finally asked him if he was interested in moving to Sitka and doing legal work for the tribe, so we could really get serious about developing the tribal court. So he did. Him and his wife-to-be moved up to Sitka. At the time, we were administering housing over there on Alice and Charcoal Island over by the airport. We had entered into a long-term lease agreement with the Native Corporation, which had engineered a land exchange as part of the Anilka law that passed in late 1980. So we exchanged a couple of landslides that we had from our original land selection out in Catlian Bay for Alice and Charcoal Island. I don't know, it's about 25 acres. Pretty valuable land, though. And at the time, our corporation that was in the glory days of our corporation. When I was on the board, we were bankrupt virtually the whole 9 years I served on that board. And they didn't know what to do with the land. They had no plans, so they leased it to the tribe for nothing. And we put in new water and sewer system. Anyway, I'm going on and on. But anyway, when Jim came to the tribe in 1984, and he was there for about 4 years. And at that time, we accomplished an incredible amount of, I think, groundbreaking work. And I think his main legacy was working as the legal power behind Judge William Brady. And I'm honored to introduce him today. We adopted him. My Uncle Charlie, my late Uncle Charlie, adopted him into my clan, the Sitka wrangle on the wolf side. I'm proud to introduce Klu-kaa, Wolfman Jim.
I thought they were kidding when they told me what my Tlingit name meant, but they weren't. And I was honored to be adopted into the Sitka clan. We did accomplish a great deal during those 4 years. From November of, I moved to Sitka during the famous Thanksgiving Day storm of November 1984. My wife had never been to Sitka before, and we had a big U-Haul trailer, and we pulled off the ferry. She's looking around. Andy had set up a place over on Ellis Island for us to stay at, and we're, sort of trying to find the road. Okay, what did my husband get me into this time? Or I guess we weren't married yet. It was blowing pretty hard. Well, the next morning, as it turns out, they were doing some dynamite work. I had to go to work. I had to go to a meeting of the tribal council the night I got into town in November of '84, and then the next morning I kissed my wife goodbye and said I'll come home at noon. And then, little to my knowledge, it was like Vietnam, or what we might say Baghdad today. There was incredible dynamite going off by, I guess his name was Kochi, and he had no idea that the apartment building that we were occupying was in fact occupying. And that added to the fact he used a little bit too much dynamite, had my wife stumbling out of the apartment kind of like this, with these guys looking at her going, "Oh my God, there's somebody in that house? Whoa, wait a minute." And so she sort of stumbled down the road, went into the first building that she came across that had people in it, which was Andy's cousin John Littlefield, who was the head at the time for Sitka Construction Company. And to make a long story short, within an hour she was hired as the accountant for SCA Construction. So we both had jobs. She within 2 months she was hired as a professor at the University of Alaska Southeast to teach principles of accounting to rural areas in Southeast Alaska. And I know this is supposed to be about me, but she's a lot more interesting. And she's currently working for the Department of Labor, assisting elderly people receive training on acquiring new employment. I've been, my first job as a tribal court judge was in, like Andy said, I'm a member of the Jamestown S'Kallam Tribe. That's from Sequim, Washington. And it was kind of funny, when I moved to Sitka, I was wondering if anybody had heard of Sequim, and they said, "Oh, you mean the second Sitka?" I found out everybody had heard of it. Everybody's parents and grandparents were moving down to Sequim because they had heard it only got 19 inches of rain a year, so they were going to move to Sequim, which is where I grew up. Little did they know it's true. We only get 19 inches of rain a year. but there are a lot of overcast days. My tribe became federally recognized in 1979, and it was a lot of work. Maybe some of you have heard of Ron Allen. I'm a member. It used to be divided into 3 bands of S'Kallam Indians. The lower Elwha S'Kallams to the east of Port Angeles, the Jamestown S'Kallams right by Sequim, Washington, and then the Port Gamble S'Kallams, which was in those days pronounced S'Kallam, over by Kingston, where that ferry is. And they told, according to my mother, when she was in her teens, the Interior Department informed all the Jamestowners that if you want your own land, if you want an allotment, if you want to be federally recognized, if you want any rights from the federal government, you're going to have to move out of Jamestown. You're going to have to move to Lower Elwha or to Port Gamble. And about nobody moved. However, over the years, systematically, it's a function of human nature. As people did start to sell, property, and it was divided up, and surveyors came in. The Interior Department was more than happy to come in and say, okay, you suddenly now own this land in fee, whereas before that, all the land was owned in common. And it was a pretty cynical story. And that's when a bunch of us young bucks got together and said, enough of this, especially Ron Allen. I give Ron all the credit to him. And we filed a petition for federal recognition, and that's a real long story if you've ever been through that process, using the famous anthropologist from Vancouver Island, what's her name? I think she was here, wasn't she? Anyway, we became federally recognized. That coincided with my return to Sequim. So I went to, my family moved from Sequim to California, where I went to college at the University of California and law school at UC Berkeley, known as Bolt Hall School of Law. And during the summers, the 2 summers during my law school, the summer after my first year, the summer after my second year, I worked in the field of Indian law. And for 6 months in a row, during the second semester of my second year of law school, I got all of 10 credits instead of the normal 15. In those days, they only gave 10, so I had to make those up. But for working for the California Indian Legal Services, working with the Paiute Shoshones, trying to secure their water rights in Bishop, California, on the east side of the Sierra Nevada. So that's 6 months in a row during the spring of '75 while I'm still in law school, and then the summers after my first and second years. And I worked on a case called the Bolt decision, where Judge Bolt was saddled with the prospect of what are the fishing rights of the tribes in Western Washington under all these treaties that had identical language. Now, anybody heard of the Bolt decision? Yeah, just about everybody. Unless you're Ramona Bennett, this famous Puyallup Indian lady who's married to my cousin Clyde. Ramona complains that Bolt gave away half our salmon. But if most people think that we came out all right on the deal. And the name of my treaty is the treaty. My tribe is a point, no point treaty tribe. And the tribes in Western Washington all have names of treaties that were signed at locations like that by then Governor Isaac Stevens in the 1860s. And it's identical language that says the Indians have the right to catch fish in common with the natives. Now, getting a little carried away here with my background. Anyway, I moved back to Sequim, and things started popping. And one of the things I did was I wrote the first $1 million in grants for my tribe. We didn't. Our budget went from about $12.50 to pull weeds in the cemetery to $1 million to operate A&A grants and things like that. And we established a tribal court. But I also had to make a living, and the Puyallup tribe had an opening for a chief judge. And so I went to work as the chief judge for the Puyallup tribe in November of '84. I kind of have these 4-year blocks of November, to 4 years later, November. And I actually wrote the code because their code things got messed up. And under their constitution, their code, there's a lot of constitutions, IRA constitutions, that require the Interior Department to sign off on the constitutions. And our tribe just about 8 years ago amended our constitution so that the BIA no longer is required to give its approval to any amendments to the Constitution. And so we simply changed our Constitution at Jamestown S'Kallam to say the BIA has no force and effect whatsoever with our Constitution, whether or not they approve or disapprove of any doctrine, any provision in this Constitution has no relevance, and in the future they shall have no authority to affect the legitimacy of enacting and amending new provisions. So the Puyallups they were stuck with a kind of analogous situation where they had to rewrite their law and order code, because their law and order code, they discovered about 50 years too late, violated their Constitution. And so I volunteered I had just started work as a chief judge for the Puyallups. I volunteered to write the new law and order code. Everybody's probably curious why. Well, the real reason why was because I wanted to set my term. And I knew that 4 years was probably about right. I knew I didn't want to stay any longer than that, My goal was to become a judge before I was 30. I still had a year to go, so I made that goal. And I also didn't want to. You have to understand, at the Puyallup tribe, I was a full-time judge, and it was basically a criminal court. It was an 18,000-acre reservation. It was an urban setting, an urban reservation, where the state of Washington had no jurisdiction, no criminal jurisdiction on our reservation. State police, city police could not come onto the Puyallup reservation and enforce criminal laws, period. We had a large police force. We had a large jail. We had a padded cell. It's kind of a funny story. When I first met my wife, she didn't believe that I was a judge, because I had asked her out for a date. I thought she was pretty cute, and she had a good, nice smile and everything, and I just kept her laughing by doing my juggling tricks and my magic tricks and my tricks with my dog, and she thought I was some kind of a goofy magician or something. So it was a Saturday, so I took her down to the Puyallup tribe. She said, "What do you do for a living, by the way?" I said, "Well, I'm a judge." That really? Yeah. Well, what do you really do for a living? No, I'm a judge. Yeah, right. Well, come with me. So we pull up to the cop shop, and there's about 5 policemen on duty on Saturday. And they, "Judge, what are you doing here today?" well, I just came here to show my new date that to prove that I'm really a judge. And they go, oh, yeah. Then she laughs harder than ever. So I said, follow me. And we go through all the cells, and there's about 3 or 4 guys doing time. And then I said, here's our padded cell. And I gave her a little nudge, and I closed the door and locked her in the padded cell. And said, you're free to come out as soon as you acknowledge that I am a judge. It didn't take long to convince her that in fact, I was a judge. And but that was a full-time criminal court judgeship is what that was. And it got a little tiresome after 4 years. You know, why didn't I say 3 years? I kept kicking myself. Why didn't I say, you know? But it was very exciting, and we had some very, very exciting cases you wouldn't believe, cases involving very famous characters, very famous murder trials. A guy named Bob Sitka conspiring on several occasions to kill Ramona Bennett, my cousin's wife, who was ultimately indicted under the RICO statutes for 24 count felonies under RICO. And that's a real long story, but he made his way, he got himself separated from the trial he was president of the council and the vice president. The vice president was the kind of guy you look at him and you say, guilty. I mean, you know, this guy just looked guilty. So he got himself separated, and the federal judge actually, it's a long story, I won't get into that part of it. She called me up, and she said, Satyek got my attention and wanted to talk to me in chambers and claims that he just found out that you punished under the tribal court bar his attorney for misbehaving in tribal court. And I said, well, yeah, that's true. She said, well, could you fax me up a copy, or I got a copy to her somehow. Anyway, I said, I suppose it's true that, as far as I know, I mean, he wasn't a part of the case. It could have happened, and he didn't necessarily. I have no reason to believe that he knew. And he got himself out of that case, got himself separated, escaped to Canada, and they gave him political asylum. So we had things like that going on all the time. It was a crazy tribe. But at the same time, I'm developing the tribal court at my tribe, at the Sitka Tribe. And I'm also becoming a tribal politician of sorts. We had, there was 3 of us, Judge Betty Fry, Chief Judge of the Colville Tribe, myself as Chief Judge of the Puyallup Tribe, and Judge Mary Turgeon, the Chief Judge of the Northwest Intertribal Court System, who were very disenchanted with the available training. And we formed our own organization called the Northwest Tribal Court Judges Association. I was elected the first president, and we changed things around and had a lot more progressive and interesting training. And that was when Mary Turgeon was Chief Judge of the Northwest Intertribal Court System. And I'll talk about that more in a minute when we get to the Metlakatla case. And so the Northwest Tribal Court Judges Association still exists and covers the 5 states of Alaska, Washington, Oregon, Idaho, and Montana. And they still have training sessions, although not quite as often. There's also an organization called the National American Indian Court Judges Association that have meetings even less often. But I was vice president of that organization, and that's how I actually got sent to Sitka. Andy Hope called them up, and he got the story a little bit wrong. He called them up and said we could use some technical assistance. And so they met, and before I was an officer of the board, and it was in 82, not 83. He said 81, which is correct. They said, how about Bowen, Judge Bowen? You know, he'd be good. So that's how I got to Sitka to begin with. And and started developing a tribal court at Sitka. And I'd come up on an increasingly frequent basis and just lay out the basics of what the jurisdiction of the courts are in Alaska, because it's completely different than the jurisdiction of the courts down south. Completely different. It's like going back 100 years. It really is. Ben's going like this. He knows. I mean, it's unbelievable. It's unbelievable. You know, we had a meeting at the National Judicial College where we brought, we invited them all, but 3 of the U.S. Supreme Court justices showed up: Sandra Day O'Connor, Justice Kennedy, and Justice Souter. And they just flat out admitted, especially Justice Sandra Day O'Connor, they just flat out admitted, we realize that our precedents are not consistent when it comes to Indian law. We realize that they're mucked up. they didn't try to defend them, and you can see it. It's frustrating as heck, you know, when you're working hard, writing a brief that you believe with all your heart you should win, and you lose 9-0, not on the law, but because that was a mood there in that day, or whatever. Our politics, you know, it's politics is what it is. You know, for the most part, justices who are appointed by liberal Democrats tend to vote in favor of Indians on Indian issues, and conservative Republicans tend to vote against Indians. Surprise, surprise. All right, so Hepler versus Perkins. Hepler versus Perkins involved a young girl who was 5 years old. She was a member of a clan of the Raven moiety, and she had a mother who had her taken away by the mother was Tlingit, full-blood Tlingit, and the father was a non-Indian living in Angoon, a fisherman, and he sort of swiped the kid away and took her down to Grays County, Washington State. And the Sitka Tribe got sued under the Child Support Enforcement Act, and it was pending at that point in the Sitka Superior Court. Well, not for long. Within a matter of hours, it was also pending in the Sitka tribal. No, I have it the other way around. It was first pending in the Sitka Tribal Court. As soon as we found out about it, we held an emergency hearing and declared the child a ward of the court. And the Sitka Child Welfare Agency conducted an investigation, and we could see what was coming. And we declared the child a ward of the Sitka court, and then we received service of papers on us by this law firm that's used to be kitty corner from the bank, Wallenberg, and there was 2 other partners. Wallenberg was the active attorney on the case, and he had assured his clients for $500, you know, and just a couple hours of time, they'd get he'd make sure they get their kid back, because under the Uniform Child Jurisdiction Act, it wouldn't be a problem at all to get the child back. Well, we made sure it was a problem, and we weren't about to give up our kid. This is a child of the tribe, of the Raven moiety, and the mother, to the extent she was capable, had custody of the child, but she was also involved in divorce proceedings and had to go through, engaged in a lot of travel back and forth between Sitka and Grays County, Washington, and the Sitka court didn't, its head was kind of spinning at this point, and it really didn't know what to do. As I wrote in the decision, Ms. Hepler's experience over the past few years in attempting to acquire custody of her daughter constitutes nothing less than a personal and procedural nightmare in which actions are currently pending in this court, the state superior court here in Sitka, Alaska, and the U.S. Court of Appeals for the Ninth Circuit. Until recently, a lawsuit involving many of the same issues was also pending in the state superior court in Grays Harbor County, Washington state. On March 20th, 1986, that action was transferred to this court. The pending legal issues in these courts are complex, involving applications of written and customary tribal law, federal law, the laws of two states, and the relationship as among these laws. The records in these courts are voluminous, but do reveal the basic facts given rise to this litigation. Now, I promised to give you the citation where you can find this case, and you can find the other two cases, which I'll talk about for a few more minutes. And you go up to the Sitka Library during the week. It's locked on the weekend, I just found out. And it's on the second floor at the end of the hallway. You walk up the stairs and take the hallway that's on the right once you're at the top of the stairs. Walk in there like you own the place, because you do. And there's a book, a set of binders called the Indian Law Reporter. And Hepler versus Perkins, it says Sitka, first it says the name of the court. Sitka Community Association Tribal Court, which is what it was known as then. Hepler v. Perkins. And what you're looking for is the page number up in the right-hand corner. This says 13 ILR 6011, May 1986. Now, every month in this purple-bound three-ring binder, all the important tribal courts that have been published, tribal court decisions, are published in the Indian Law Reporter. So they're month by month by month. This is May 1986. What this means is volume 13 of a book called Indian Law Reporter at page 6011. So that's how you find it. You go down the row of binders and you can see the month and the date, but mostly you're just looking for 13. 13, yeah, I see 9, 10, 11, 12. Okay, this must be it, 13. Then you flip to the back, and the last section, the last tab, is the Indian Law Reporter. And you turn to page 6011, and you'll find this case. And you can make photocopies of it. And it's about, this many pages. I think it was about 35 pages, but this is in small print. And probably the most significant aspect of this case was the court and Judge Brady. I was the law clerk for Judge Brady. Now, judges always have law clerks working for them. This is nothing unusual. It's no big secret. A judge decides how he's going to rule. He tells you what he wants done. Here's what I would like drafted. He had a bad habit of every time we're at the same workshop at least, he'd say, by the way, Jim Bowen wrote every word of this. I'd sit there and cringe. But I didn't write these words, so it wasn't always right. We referred the case to a meeting of the Sitka Court of Elders, which was composed of the representative heads, clan heads in Sitka. Al Davis Frog House, et cetera, et cetera, et cetera. And we'd have about 8-10 people there, Al Perkins, so on and so forth. And those folks comprised the Sitka Court of Elders. And we submitted it to them. And to me, I'm sitting there, I don't speak Tlingit, and I'm going to talk about Bowen, right down, So they tell me afterward exactly what they said in Tlingit to make sure I'd get it right. And we presented the issue of whether or not the Sitka Tribe has jurisdiction over this Indian child, regardless of what's going on in these other courts. And at page 6017 of the Indian Law Reporter, you'll see, and I think Andy published it separately in your materials, you'll see finding of traditional law by the Sitka Community Association Court of Elders. And it reads, and this is the Court of Elders now, advising the tribal court. The tribal court doesn't have to adopt this, but it's seeking advice from the Court of Elders on what it should do with respect to jurisdiction over this child. And the finding of the Court of Elders reads, this court, having considered the question of tribal and clan jurisdiction over children born to the female descendants of members of the several clans comprising the Sitka Community Association Indian Tribe, finds, under traditional Indian law of Southeast Alaska, there is no question as to jurisdiction and responsibility for children of female clan members. Traditional law holds, quote, children of female members of a clan are children of the clan regardless of or where or under what circumstances they may be found. Clan membership does not wash off, nor can such membership be removed by any force or any distance or over time. Even in death, clan membership continues, and in rebirth is it renewed. The court went on to hold, therefore this court holds that the children of female members of the several clans of the tribe never leave the jurisdiction of this court, and that responsibility of the clans for the children of the clans comprising this tribe shall remain under all circumstances, and further, that clan membership can neither be changed or removed even in death. It goes on to analyze state authority. I'll leave that to you to read. I won't go through every single detail of this case, but the long and the short of it is we won the case. I traveled down to Grays Harbor County, Washington State, along with I was the attorney for the tribe. A legal services attorney by the name of Van Sanders was the attorney for Arlene Hepler, the mother. We held a deposition of the parents, and we had a hearing with the judge, and the case was transferred in a final manner to the Sitka Tribe. Any questions so far? By the way, if there's any... Well, it's not just that case, but the Sitka Tribe, as far as I know, the Sitka Tribe was, without a doubt, the first tribe in Alaska to have not just one, but 5 siblings together. Before this case, I showed up at work, and there's all this scurrying about. No, I came back from lunch. There's all this scurrying about. Guess what? 5 of our kids are found down in Ketchikan, and the judge seems favorably disposed, Judge Schultz, to transfer jurisdiction under the Indian Child Welfare Act unless a district attorney argues otherwise. And so I got the next plane down to Ketchikan, and I talked to the district attorney, who was a very nice fellow, and saw it our way. And never before had children of a tribe that were in the custody of the state been transferred to the jurisdiction of the tribal court and the tribe's social services agency. And these were 5 siblings. And we really set a precedent there. And that would have been early 1981, around 1981 or so. So that actually was a remarkable case. Very, very few people know about. Very, very few people know about. So we accomplished quite a few amazing things for the tribe. You know, the part of the preamble to the Indian Child Welfare Act, a little dramatic, but nonetheless reads that children are the most important resource of the tribe. And of course that's true. And that's why it's true to preserve the integrity, welfare, and presence and a culturally appropriate setting of the children of the tribe. So Hepler versus Perkins happily ended happily. Now there's a case that there's no way it was going to end happy for everybody. Remember, the name of this topic is case law in Southeast Alaska. This is the kind of case a judge has nightmares over. They had been through 3 attorneys and 2 judges before they came to me and begged me to take the case. Why me? They knew that I had experience, and I knew the people in the court at Metlakatla through my activities with the Northwest Tribal Court Judges Association. They knew that I had handled Sequim versus Sterud and another case involving Sequim where Melvin Belli was paid $25,000 to come up and practice in front of me, and made all the front pages, and I ruled against him. When I was glad that I was down on his hit list when I found out that there was at least 2 or 3 other people that he was planning to off before he was going to go after me. I'm not kidding. Anyway, Metlakatla, as many of you know, the name of the case is Holt versus Kalapa. And the case that I issued is, here it says Metlakatla Tribal Court of the Annette Island Reserves, Holt et al. Versus Kalapa et al. That means they're not the only named people. There's Holt and others, and then Kalapa was actually the new minister, the most recent minister, and it can be found at 14 ILR 6007, which is volume 14 of the Indian Law Reporter at page 6007. So that my decision in Holt versus Kalapa can be found at 14 ILR 6007, which is the February 1987 version. Now, after I finished this very emotional case, they decided to hire an appellate court. And first, let me tell you that what the subject matter of the court was, which was amazing by itself. It was a lawsuit between 2 church congregations. Now, how much more emotional can you get than that? And further, don't forget that Father William Duncan is the Anglican missionary that brought the Tsimshian Indians, who were more or less his followers from the old Metlakatla on Vancouver Island, where he was having political difficulties with the Canadian government, and worked out a deal with the federal government of the United States to set up a new residential area at New Metlakatla, which, as we know, you all know, is on the Annette Islands, to the west of Ketchikan. And Father William Duncan, I highly recommend the reading of a book called The Devil and Mr. Duncan. It's a very, very well-written book. And what I could tell you one thing, I'll just say generally. Before reading the book, I had heard certain bad raps about the guy. They're not true. The author did a very, very thorough job of researching, and if he's to be believed, and I have no reason not to believe him, Father William Duncan had a temper, and he would document in his diary. Sometimes he felt badly that maybe he punished some of the children a little bit harshly, but it never went beyond that. It never went beyond that. And he had a lot more strengths than he did weaknesses, I can tell you that. And I didn't know anything about the guy before I read this book and other books about him. Then I couldn't wait to read more. A fascinating guy. So what happened is Duncan I'll read the summary of that the Indian Law Reporter drafted. Plaintiffs, the Congregationalist group of the William Duncan Memorial Church, brought suit to challenge the defendants, the Assembly of God group of the William Duncan Memorial Church, affiliation with the Assemblies of God Church, on the grounds that the meeting at which the congregation of the William Duncan Memorial Church voted to formally affiliate with the Assemblies of God Church was unlawfully conducted, and that the affiliation violated the trust established under the will of William Duncan. The Metlakatla Tribal Court finds that the meeting of the congregation was lawfully conducted, that there was proper notice to members of the congregation, and that the William Duncan Trust was terminated in 1976. The court thus holds that the affiliation of the William Duncan Memorial Church with the Assemblies of God Church does not violate the terms of the trust. Now, at this point, I had just very narrow legal issues to decide. They had been through agonizing fights and infights and bitterness within that community, which, as I wrote, that summary I just read was written by the editor of the Indian Law Reporter, but what I wrote was, this is an extraordinary lawsuit in which two religious congregations compete over control of the William Duncan Memorial Church and related property and assets located at the Metlakatla Indian Reservation. The divisive dispute continues to unsettle what is otherwise a rather idyllic Indian community. Today's decision provides an unequivocal legal ruling regarding plaintiffs' legal claims, and thereby some certainty to assist each group in planning for their future welfare. However, because of the entrenched positions of the parties and the emotional subject matter, more time and effort in non-judicial settings will be required of the many good people on both sides in order to heal the pernicious wounds inflicted by this conflict. And so you can see what I'm trying to say. You can see that what I'm saying is I've given you a definite legal ruling. That's what I was hired to do. They voted 50-8 to become affiliated with the Assemblies of God Church. the question was it a legal vote? They tried a lot of different approaches to say it wasn't legal. I handled them one at a time, and I said it, and this has nothing to do with whether you like the Assemblies of God Church or you don't. I mean, I don't happen to be a member of it. I don't have any biases one way or the other in terms of religious affiliations. Trust me. And they had already litigated whether or not a case like this was litigious, meaning whether courts can properly entertain lawsuits between two church congregations. They had at least gotten that far and decided that yes, they could, which is the correct legal decision. But then things fell apart once again, and finally they called me up, please, can you handle this case for us? And I conducted about a 4 or 5 day trial, I think. And then I knew whichever way I ruled, half the people were going to be unhappy. Well, that's the way some cases are when you're a judge. That's just the way it is. But your job is to be an objective judge and to make your decision according to the applicable law. What's the applicable law? Tribal law. Surprise, surprise. There's not a wealth of tribal law that addresses the specifics in a case like this. This issue hasn't come up thousands of times, believe it or not. So, but it's important to note that, and I've written articles on this. One article is called Choice of Law in Tribal Courts. The starting point as a tribal court judge is always to apply tribal law. And never forget that unwritten, oral, custom law can be every bit as binding as written law. Now, of course, it's handy, and as a function of providing notice to the community of what the law is, useful that tribal law be put in written form. But the great Indian law author Felix Cohen and many others, John Marshall, Justice John Marshall, so many others have emphasized the point. My favorite judge, Judge William C. Canby of the Ninth Circuit Court of Appeals, a friend of mine, has emphasized over and over and over that oral custom law can be every bit as binding as written law. Well, after my decision came out, you know, like I said, any way you look at it, things were still going to be, there was still going to be a lot of disgruntlement. They hired I thought they did the right thing. They hired an appellate court. It's always good to have an appellate court. Always. I highly recommend appellate courts. If you set up a tribal court system, you know, absolutely. You know, it's always a good idea to have a tribal court make sure that one person didn't get carried away and make the wrong decision and go off half-cocked. You need, you know, 3 dispassionate people who weren't in the courtroom who are deciding even narrower issues. Just the legal, that's the narrowest possible legal issues, who didn't need they just need to read the transcript, are very useful. How many appellate courts you have? Well, we know how many the United States has. It's got the District Court and Court of Appeals, the United States Supreme Court. You don't need that many, but I would recommend at least one for every Indian tribe. The Metlakatla Tribal Court did a very good job in finding three dispassionate tribal judges. They went to the Northwest Tribal Court judges. The Northwest Intertribal Court System, which is a good idea because I wasn't involved in this Northwest Intertribal Court System nearly as much as I was. I had some, not at that point in time, but historically I'd had more involvement in it. They went to a competent organization that was in the business of contracting judges, tribal court judges, to hear cases around the Pacific Northwest. Makes sense to me. And they came up with three judges by the name of Hosnick, who I don't know, Fry, and Irvin. And I told you the citation of my decision. Citation of the appellate decision in Holt versus Kalapa is 60 Indian Law ILR 6070. That means volume 16 of the Indian Law Reporter at page 6070. 16 space ILR space 6070, which is in the June 1989 volume of the Indian Law Reporter. And again, it's their purple in color, their 3-ring binders, and the tribal court stuff is in the very back. The chair recognizes John Littlefield.
Thank you, Judge Bowen. I had a question on a comment that you just made, and I have to attend another meeting, and I would hope to, maybe you could talk about this a little bit. I believe your words were that oral traditions were as binding as Western law, and I really support that. But my question to you is, what happens when you have 4, 5, 6 oral traditions that are different? How, I know what Samson did. What would you recommend in that particular?
First of all, what I said was oral law can be every bit as binding as written law. I don't think I said Western law. And then during the break, it's interesting that you asked that question, because during the break, Walter asked me, I think it was you, Walter, said, now, are you talking about oral law that's 100 years old, 200 years old, 300 years old? And my answer to Walter was, I made 2 points. First of all, I would say that if written law doesn't answer the question in the first instance, because I think written law is always preferable, it's more specific, it provides better notice. But if you don't have written law addressing a specific legal question that needs to be resolved, then whatever unwritten custom law is considered binding in the community at that time. And the second point I would add to that is that traditional law doesn't mean what the 5 or 10 oldest people in the village say are the way things used to be. That is not traditional law. That is not what I mean by traditional law. Traditional law, I believe, can be dynamic, binding, evolutionary, and changes as a matter of the mores of the community. And as the community changes. This might not be the best analogy in the world, but some romantic-minded non-Indians say, why do you guys have these outboard engines on your canoes? I said, why do you ask such stupid questions? Things change, and things don't necessarily need to be static. And so if you have the same question that would be answered differently as a function of oral law 10 years ago versus 100 years ago versus 500 years ago, I would say the answer to your question, John, would be how would the question be answered according to oral tradition today? Any other questions? Yes.
What are the powers of a tribal court, and are the decisions upheld and enforced? And if they are enforced, how do you go about doing that?
Can you restate the question for the record, please?
I'll restate the question. What are the powers of tribal courts? How are they enforced? How do you go about enforcing them? And my first reaction is I hope nobody's doing anything for the next 2.5 months because that would just start to take a bite out of the apple. That's impossible to answer with any specificity. You'd have to put it in context, in a subject matter context. Now, I like to, when I talk about jurisdiction, for example, and this doesn't even begin to break it down into sufficient specificity. I like to, if I had a board here, I'd write jurisdiction, 1, territorial, 2, personal, 3, subject matter. Territorial, what territory does a tribe have jurisdiction over? What land base? 2, personal, what people does it have jurisdiction over? 3, subject matter. What subjects does it have jurisdiction over? Does it have jurisdiction over crimes? And all of these have 100 questions within each general subject. Within territorial, I could come up with 100 sub-questions and 100 sub-questions in the other two as well. And so that's why I say it's impossible to answer such a general question like that. It's simply impossible.
It's not so general in my mind, because if a federal court, probably U.S. Marshals would come in there and back up any decision that the federal court makes. Now, this is a tribal court. Having to do tribal, does that mean like Native American? Does that mean our culture? What exactly is a tribal court? This is something that's been mentioned to me. There's been times where some things are being done that we don't know where else to turn to, as we can't turn to a non-native court, and it's been suggested that a tribal court might be able to help. So that's why I'm asking, what exactly is a tribal court?
Have you ever heard of plenary power?
What?
Have you ever heard of plenary power?
No.
Okay. Plenary power, and I raise this subject not to be a wise ass, but to answer your question. Plenary power, it's a doctrine of Indian law, and it's actually in the United States Constitution. Indians are the only ethnic group mentioned, other than Negroes, what were they counted for? 3/5 for slaves, but that was removed. Indians are the only ethnic group mentioned in the federal Constitution. And they're mentioned in this way. Congress shall have plenary authority over Indian affairs. Okay, fine, as far as that goes. What is plenary power? How do you define it? Usually it means they can do anything they want. The U.S. Supreme Court has upheld just about anything Congress has tried to do with respect to, because it gets them off the hook. It gets the U.S. Supreme Court off the hook. You know, it gives them something to, it gives them an out. They always cite the plenary power provision when they don't know what else to do. They say, well, because, you know, Article 10, Section, you know, 9A says that Congress shall have plenary authority over Indian affairs. We necessarily defer to our sister branch of government, and therefore we stay our hand and uphold the act of Congress. End of story. So whatever Congress, whatever act Congress passed affecting Native Americans, we uphold. The best definition I ever heard of plenary power, however, was by this guy named Bob Sitka, this famous Puyallup Indian, who, the end of the story, by the way, is he died of a heart attack at the age of 53 after he was given political asylum in Canada. And after he had tried to murder my cousin while she was 8 months pregnant with she tried to murder my cousin, yeah. He tried to murder Ramona Bennett when she was 8 months pregnant with my cousin's son, as it turns out. So it would have been my cousin. Anyway, none of us knew that at the time, and that's another whole story. The feds waited until I made my decision on recalling Sitayacum, and then on Monday, front page of the newspaper, title, Tribal Court gives go-ahead to recall election. Next title down, Sitayacum and Cross recalled. Next title down, Sitayacum indicted with 24 felonies under RICO statute. You know, they waited until I ruled so that they weren't seen to be influencing what the tribal court did. But getting back to plenary power, Bob once said, we're talking about, I didn't have all that many conversations with him, but he was just sort of, I don't know, there's a handful of us talking about plenary power and how the feds, you know, obviously you don't take on the feds. And Bob said, well, after all, plenary power simply means they got more guns than we do.
What's that?
Plenary power means they got more guns than we do. And to me, that makes all the sense in the world. So you can have a tribal court issue whatever ruling it wants, but if the tribal court is wrong as a matter of federal Indian law, you can bet your life that the side that lost in tribal court is going to file a writ within the next hour in the local United States district court, and that district court is going to rule that the tribal court's order is null and void, and the sheriffs, the federal sheriffs who have more guns than the tribal police force, are going to uphold it. So the answer to your question is, that's how federal Indian law gets upheld over tribal law. Federal Indian law always trumps tribal law.
So tribal law isn't like a court, like let's say some clan member is hanging on to regalia that doesn't belong to him and is not paying attention to the rules, and we came before you. That's not what a tribal court does.
No. That's not correct at all. That's not correct at all. a moment ago I said the first thing a tribal court judge says to himself or herself is, what is what is the applicable law? The applicable law is always tribal law, and it might be unwritten tribal law. And if it's a case involving regalia, and if it's a case involving, let's say, just hypothetically, that there's a hypothetical village called Klekwan, and some group claiming to have authority go to Klekwan at night, and on their third attempt managed to remove, I'm just speaking hypothetically, the whale house artifacts worth millions of dollars if they were to go on a sale in the open market. It turns out that after 10 years of being in a warehouse in Seattle, because the federal judge accepted the petition, the motion for an injunction, Judge Vonderheit, and waited for the tribe to get its act together and establish a tribal court, which is also consistent with federal law. All this time, these artifacts, and this just very conveniently ties us into the final case I was going to talk about, Chilkat Indian Village versus Johnson, the case I decided up in Klekwan. If there is no, what happened in that case is actually very interesting, but the long and short of it is, if there's no direct conflict between federal law and Indian custom law, then the federal court would be more than happy to enforce tribal custom law. And I don't know of any federal law that says otherwise. I don't know of any federal law that says it's okay to steal this just by making the claim that you're a member of this family. I don't know of any federal law that says that. And look what happened. It is federal law procedurally, since a case in 1981 called Rice versus Riona, that the United States Supreme Court said when these more and more cases came out of tribal court, and they're just giving these federal judges, they were just pulling out their hair saying, what on earth are we going to do? You know, Congress passed this thing called the Indian Civil Rights Act in 1968. That's right, it was exactly 10 years later, 78 is when that federal decision of the U.S. Supreme Court came out, Rice. In 1968, Congress passed this law that said tribal courts must provide not all of the rights of the Bill of Rights, but most of them. It has to give you the right to due process, equal protection. However, you're not entitled to have an attorney appointed for you in tribal court if you're too poor to afford one. And so it didn't include all of the rights of the Bill of Rights. It just decided to include some of them. Why do you ask? Because they're cheap bastards. If you ask me, they didn't want to have to pay for them. That's the basic reason, I think, as far as I can figure by reading the congressional record. Another interesting fact is United States this is an accurate legal statement today. The United States Constitution does not apply to tribal governments. Just for the sake of emphasis, I'll repeat it. The United States Constitution does not apply to tribes, does not apply to tribal governments. So if you go to the United States Constitution and you find some right in there, it doesn't naturally follow that the tribe has to enforce it. I mean, tribes were here first, not the other way around. Never forget that. At the same time, that's why we have this mishmash of Indian law. And it makes good living for some of us who have taken the time to figure it all out, but it doesn't make a damn bit of sense, when it comes down to it. I mean, there's a lot of contradictions in federal Indian law. There really are. As Sandra Day O'Connor said, but that's because she got so confused by dating William Rehnquist when she was at Stanford Law School. But in any event, yes. Is there any other questions? Yeah, Walter.
Jim, I was wondering if you knew Rupert Ross and if you could explain a little bit about what he's doing in Canada and to support the federal government.
Why don't you tell us?
I'll try. So anyway, Rupert Ross is a magistrate in Canada, and he's taken an interest in natives handling their own problem solving with criminals. And if you read about him, he's got several. He's got a third book out now, and the first book I believe is Dancing with the Ghost. Is that right? Are you familiar with that? It's called Dancing with the Ghost, and the native communities over there, and the primary issues that they're dealing with is sexual child abuse, and which is a very difficult issue for anybody to try to deal with. So anyway, for some reason he took an interest, and some of the tribal people said, why don't you let us handle these things? We can do better. We don't think that sending people to jail over these issues really works. You just send them to jail and they're in for 5, 10 years or whatever the judge or magistrate decides on doing, and they come out and they're the same people. They get to drinking, and next thing you know, they're abusing another child. And we think we can take this person and work with him, and we'll get rid of this portion of him so he won't do that anymore. And plus, he'll become an upstanding citizen back in the community. So anyway, he took an interest in it, and he started getting invites from native groups, and he encouraged them to demonstrate these kinds of actions. And he not only saw the value of doing that, he started suggesting to the Canadian federal government they should take a look at this. And he asked to be sponsored, and the federal government give him enough money to pay his salary as a normal magistrate, but his sole purpose is to go out and document native people solving problems in what they considered a traditional manner. So anyway, my question to Jim, is there any interest in America for us going back to what I call traditional problem solving, not court systems, problem solving, and making it a community issue rather than an individual issue? Like I could cite, when my sons get in trouble, they can go to court. I don't even have to go down there. It's not a community issue. Nobody in a community needs to go down to the court.
I'll tell you what the answer is. And I'll tell you where it's happening is Mike Jackson at Cake. And I think he's supposed to be around here, isn't he? Yeah, so that's the person that I would defer to on that question.
Well, my question to you, Jim, is there anything like that going on in the country where the court or the government takes an interest in? That's my question.
Well, what does it mean to take an interest? We're all familiar with the rate of recidivism of sexual abuse. We're all aware of that. Your example had to do with natives being aware of it. Well, non-natives are aware of it also. The last thing I heard you say was, how about getting the whole community involved? And maybe that would be closer to a traditional approach to reducing the rate of recidivism in this area. And it's being studied to death. And there's people getting PhDs every month at least. This is being studied to death. And because the rate of recidivism is so high, and they study the brain and what makes people, behave, this way. Why are they compelled to do this? I think we're getting a little far afield from traditional methods, but what my understanding of what Judge Mike Jackson has going down in Cake is the circle. What's it called? Peacekeeping circle peacekeeping. Yes, and I would respectfully defer to him, and I have a lot of respect for him. So one more thing, and then we got to wrap it up. I'm told we're out of time. I'm going to give you the citation for the very famous Chilkat Indian Village Tribal Court versus Johnson. And this one was in the newspaper, in the Anchorage Daily News. There was a series of 5. Well, anyway, it was a big deal. Here they are. This author for the Anchorage Daily News, Marylee Angee, did a series of 5 articles that were long with the colored pictures, which this doesn't have. But they're colored pictures from the DeMille collection of the actual artifacts, the worm dish, the each house post, and you can find this if you're familiar with the internet. You could find this by Googling, doing a research. Probably you could go to the first page. It's called Whose Laws? Or just whale house artifacts, something like that would bring you to the page, and the series of 5 pages, and the series itself is in color, which is dramatically different, of course, than in black and white. But did I finish giving you the? It's the whale house artifacts. Citation in the Indian Law Reporter is 19 ILR 6010 from February 1992. This is what the Anchorage Daily News and the Sitka, the Juneau Empire referred to as my 70-page decision, which, when it's single-spaced, and you use both sides of the paper, I was saddened to find was more like about 20 or 25 or something, but no. What was that? Yes, it's 19 and then space ILR, which stands for the Indian Law Reporter, space 6010. So in other words, you go to volume 19 of a book called the Indian Law Reporter, which is right up here on the second floor of the Sitka Law Library, and then you turn to page 6010, and it happens to be the February 1992 edition of that book. It's a maroon-colored book, and it's called the Indian Law Reporter. And with that, and we'll wrap it up, and thank you very much for your attention today.